My lord, writ petition hearing of 2014, my lord. Let it be added in the list.
The sub notice.
Yes, yes.
Under 2014 and 2020 matter, Lordship, I have served.
My lord, this matter, my lord, I am the petitioner. This matter is running in the today's list as item number 107. The crux of the matter is that, my lord,
What do you want?
my lord, I want upgrading the matter, my lord.
Upgrading is not possible.
My lord, there is an urgency, my lord.
What is the urgency?
Urgency is that this person has been out of service since 2019. And the person only source of income is through service. He has been removed from the service by departmental inquiry, and his family is facing the crunch, the financial crunch, my lord. For that reason, my lord, and this person is coming from UP, my lord. He is
Upgradation cannot be done. If you want, I can release that.
if my lord can fix this matter, my lord.
Hearing matters, no upgradation. Yes, call the list.
Application for restoration.
Grateful, my lord.
Application for restoration.
When it was dismissed.
My lord, it was dismissed on, my lord, 7th December 2023. My lord, I have previously, my lord, on notice, my lord, I am serving. My lord.
May I have your lordship leave to mention on notice, my lord, original side matter, my lord. It was already allowed earlier, your honor, my lord. Or lordship, one application for substitution.
This is the OTP matter. Excuse me. Excuse me. Is it the OTP matter?
Lordship, one application for the petitioner is here.
Maybe
Included. Original side.
when to be taken up, I cannot assure.
Lordship, one application for substitution on notice. Application for substitution.
Within time.
Without time, 200 days. Overtime.
My lord, inclusion for hearing, my lord.
Your sub notice.
Sub notice, my lord. Copies.
Yes, call the list.
I don't know, three in this matter. The application for application for restoration, but on the last, according to your lordship view, is the main matter. Main matter.
What is the main matter?
Some difficulties is there.
Please use the microphone. Use the microphone.
Yes, sir. Some difficulties is there. So I pray for the adjourn for 2 weeks regarding the main matter and
Main matter adjournment. So entire thing is to be adjourned. The learned advocate appearing for the petitioner prays for an adjournment
for 2 weeks.
in
2 weeks.
2 weeks. As prayed for by the learned advocate for the petitioner, let the matter go out of the list with liberty to the petitioner to mention for inclusion after. To mention for inclusion. Yes. Next.
Regarding
Lordship, may I humbly request for, as the application is appearing, Lordship, may kindly.
No. Matter will be taken up.
It's a request.
Oh, no piecemeal thing. Yes, next.
As I am appearing for the authority, Lordship, that if a order is recorded, then it will be grateful, Lordship.
Yes. Order I can record. The learned advocate for the respondent is present. Certainly correct.
Grateful, Lordship.
Yes, next.
I'm for the petitioner, your lordship.
You're for the petitioner?
Yes. Your
Yes.
lordship, I am praying a week adjournment, your lordship. There are certain instructions that needs to be taken. On the last occasion, your lordship would see the matter was dismissed for default. Thereafter, it was restored. Before that, your lordship, there was a direction of paying invocation of bank guarantee by the respondent, which has been done. Thereafter, there was a direction for filing affidavit in reply, your lordship. That is still not being done by the petitioner.
How much time you want?
2 weeks time, your lordship.
As prayed for by the learned advocate for the petitioner, the hearing of the matter stands adjourned for 2 weeks. Next.
My lord, sir, I'm appearing for the respondent number 2.
You are appearing for?
Respondent number 2, my lord.
The learned advocate for the respondent is present. Next.
Obliged.
My lord, I am appearing for the petitioner, my lord. I am suffering in fever, my lord. Kindly pray. I am praying for not today.
As prayed for by the learned advocate for the petitioner, hearing of the matter stands adjourned for the day. Next.
Grateful, your lords.
My lord, item number 7, sorry to interrupt, my lord. My lord, item number 7, my lord, for quite a long time they are seeking for an adjournment. My lord, kindly fix this matter, my lord. I am suffering an injunction, my lord.
It will appear. Yes, next.
My lord.
9.
It was called on. Nobody was there. Yes, 9.
মিউনিসিপাল কমিশনারের নাম চেঞ্জ করতে হবে, চেঞ্জ হয়ে গেছে।
None appears for the petitioner at the time of call. No accommodation has been sought for either. Accordingly, the application for restoration stands dismissed for default. Yes, next.
10.
Lord, 10, my lord, contempt. Lordship was kind enough, my lord, to allow our writ application. And thereafter, my lord, when we filed this contempt application, they preferred
Appeal.
appeal. And thereafter, the appeal disposed of. This is, my lord, the order of the appeal. And finally, my lord, the Supreme Court is also of the opinion. Finally, in the Supreme Court is also of the opinion, my lord, upheld the order of this honorable court, my lord.
Yes.
So now, my lord, there is specific direction within a stipulated period of time, my lord, that overtime allowances to be given, my lord.
Oh,
But
that
there is no
matter.
issue, my lord, right now, because we have at the end lost the case. At the
At the
end
end-
lost the case. Therefore, now your lordship's order has begun attend finality. Because up to Supreme Court is gone. Now, this is an issue your lordship can remember that overtime allowance to some of the engineers who are engaged in a particular position. Your lordship was pleased to give us, my lord, 2 months time originally. Now, after that, my lord, stay order and all these things gone. Your lordship give the same, my lord, period of my lord, taking
Supreme
action.
Court order was passed on 20th of January.
My lord.
Now, what is the submission now?
My now submission is that your lordship give the same time as your lordship originally gave us for calculation and all other things. Within that period, we have to take action steps. And my lord, also, my lord, that the petitioners who are before automatically, my lord, is confining to the petitioners who are before lordship and got an order in their favor. But that my payment.
But 2 months time to comply with the
Yes,
order.
sir, to act.
No,
But
but-
your lordship order is initially order was
Because
that.
the order was passed on 8/9/2022. When only we have filed this contempt
They
application.
have a right of appeal. They preferred appeal.
Yes,
The
my
order
lord.
was there.
When preferred.
The order was also
When we
there.
have filed contempt application, then only.
You have filed contempt application.
And my lord, the
but
division bench also allowed
Honorable
them. my lord.
Supreme Court has dismissed the SLP only on 20th of January.
Before that, my lord, the division bench was kind enough to grant them 8 weeks time that was elapsed. Kindly
that
see,
division
kindly
after
see
that-
my lord, the division bench order. Then only, my lord, before the Supreme.
That
They are entitled to prefer SLP.
They are entitled, no doubt. So, but at the same time, my lord, 2022 order and they are not getting.
Some time is to
Lordship,
be given
this is a
to the
discretion.
authorities to act
Well,
on that.
Well, this is the discretion of this honorable lord. I cannot stand on the way.
না নতুন অর্ডার তো দরকার না কেন করা অবশ্যই অবশ্যই যে আছে আছে সে আছে আছে
একটা মাল্টি স্টোরিতে চাবি লাগিয়ে দিন, টাকা ফাঁকা দিয়ে দেবে, ওদের দিয়ে দিন।
This is an application for contempt for alleged violation of the judgment and order dated 8th of September 2022, passed in WPA 11677 of 2017. Full stop. Mr. Chakraborty, learned advocate, appearing for the petitioner, submits that challenging the said order, the Kolkata Municipal Corporation preferred an appeal, being MAT 1636 of 2022, which was dismissed by the judgment dated 27th of September 2024. Full stop. Against the said order, the Kolkata Municipal Corporation filed a special leave to appeal within bracket C numbers 1019/2025, which was ultimately dismissed on 20th of January 2025. Just a paragraph. Mr. Ghosh, learned advocate, appearing for the alleged contemner, prays for 2 weeks' time.
2 months, my lord. 2 months.
2 months' time to comply with the judgment and order dated 8th of September 2022, passed in WPA 11677 of 2017, which has been affirmed in the aforesaid appeal. As prayed for by Mr. Ghosh, list this matter. April. Calculation part, Mr. Ghosh.
Yes, my lord. Only.
No, there are several number of persons. The calculation, my lord, not on
How
that.
many persons? How many persons?
11 persons. Then not only that, there are
11.
different
Yes,
11. There are
Yes.
my lord, circulars are there. My lord, the rate has to be, my lord, calculated over and again. Their claim is, my lord, since, my lord, long before.
Only, my lord,
Wrong
contempt to
pass.
file review application, and my lord,
List this matter on March 13, 2025.
March.
13.
But that does not cover that 2 months. You see, in the month of April, you should take it up.
Ghosh, it will be done.
But let us not say again before Lordship that some more time we give it. Also, but I hope to
Come with a compliance report on that day.
I hope to get it done, my lord. That is the reason I'm submitting, my lord.
All right, 20th of March.
my lord, only one liberty, my lord. Meanwhile, municipal commissioner has changed. New municipal commissioner stepped into the shoes of the erstwhile municipal.
So you want to
commissioner.
substitute?
I want to substitute.
As prayed for by the learned, এটা একদম উপরে লিখে দেবেন. As prayed for by Mr. Chakraborty, learned advocate, for the petitioner, leave is granted to the learned advocate on record to add the new incumbent as an alleged contemner in the contempt application. Let such amendment be carried out in course of this day.
No, only,
Advocate on record is here.
yes, my lord. Only direction may kindly be issued to them, my lord, to spelling of this name of the municipal commissioner should be. Otherwise, my lord.
Spelling, Mr. Ghosh.
Otherwise, my lord, name
He
should
knows
not be
better than me because I committed a mistake about that name.
double join, my lord. The it's proper.
Mr. Ghosh, kindly give him the exact name. Yes, next.
Deeply obliged.
11.
Your Lordship, in item number 11, I am praying for not today.
Why?
Not today.
Your Lordship,
Your Lordship, your Lordship, I meekly pray for not today. Actually, I am led by Advocate Pinaki Bhattacharya. He came to court today, but unwarrantedly, he suddenly falls sick.
Bhaskar Prasad Boisho. Where is he?
Both appearing for DPSC.
Yes, where is
I
Mr.
am led
Boisho?
by I am led, Your Lordship, my senior is Advocate Pinaki Bhattacharya. So today,
Where is Mr. Boisho? He has not come to court.
I don't have any.
No adjournment then.
I meekly pray for not today, Your Lordship.
Mr. Dattu, you are opposing that prayer
no,
on that ground.
no, if he's going to Kumbh, this is Mahakumbh, not Kumbh, Mahakumbh. I will not oppose. But only one thing, hearing has been done. Report has not been submitted. As per your Lordship's order, hearing has been
So
done.
I'm making it only not today.
Much obliged, Your
As prayed
Lordship.
for by the learned advocate for the alleged contempt hearing of the matter stands adjourned for the day. Next.
Much obliged.
My lord, I am for the petitioner. Now, my lord, here is my affidavit of service. My lord, the state has preferred an appeal.
Appeal.
Yes. Now, my
But
lord,
really, that was
just a minute.
released for some personal ground, has to be again placed before the Chief Justice.
So I'm
Lord,
directing this matter to go out of the list.
No, my lord, your lordship kindly.
Viraj,
No, my lord, there will be no pressure. Kindly adjourn the matter for a month.
Because the appeal will take some time.
Yes,
Unless
I
and
am
this
just
matter
asking.
will appear
My
in
lord,
the
kindly after 1 month. After only one
immediately
humble
after
prayer.
you mention it will appear because appeal court will take some time.
My lord, your lordship kindly. Otherwise, there will be no. They will not proceed with the case. Kindly, my lord, adjourn the matter for a month. My lord, I will not let
20th
them
March,
check.
your lordship has fixed the other
My
matter.
lord, the other matter
This
has
matter will
already
also
been
be
fixed.
on 20th
One
March.
matter, two appeals from the same judgment. KMDA's matter has already been assigned. At yesterday, state government's order of assignment has been.
So earlier KMDA preferred.
Yes, that has been assigned.
Matter where the
That has
learned
already been
advocate
assigned.
general represented the KMDA.
Yes, that has been already assigned. So kindly adjourn the.
KMDA's appeal is the exhaustive one.
Yes, so
So
my
the
lord,
state's
so my
appeal.
lord, yes, so my lord, kindly adjourn the matter for a month.
Formally, it has to
Already
be
matter
there.
has been assigned.
Formally, it has to be there, my lord.
Yes, only for a month. Just a minute, my lord. Kindly adjourn the
File টা দিন।
file টা দিন। এই যে এই এফিডেভিট অফ সার্ভিসটা একটু রেকর্ডে রাখবেন এই যে
What was the order?
order Milord, this award was passed on the basis of a lapse notice. Your lordship has quashed the notice and quashed the award.
4-1A, 4-1A.
Yes, 4-1A. Your lordship held that the award is bad and your lordship directed to pass the fresh award in default to hand over possession. But they had every right to prefer an appeal. I am not opposing that. But after this is after 24 of 2001, the writ petition was filed challenging the acquisition proceeding. Now it is 2025. Now this is the position.
Ashun.
So, my lord, keep
If
some
the
pressure.
service filed in court today is
Right.
taken on record.
Yeah.
Mr. Chatterjee, learned advocate, appears for the alleged contemner. Alleged contemner number?
I appear for all of them, my lord. All of them, my lord.
All of them?
All.
You are also representing KMDA?
The KMDA possibly
No,
is not
KMDA
a
no
party
content.
here.
Has not been.
All only state sufficient.
কি বললাম? Mr. Chatterjee, learned advocate, appearing for the alleged contemner submits that the state has preferred, that the state of West Bengal has preferred an appeal against the judgment and order dated August 23, 2024, passed in WPA 10244 of 2016. What is the number of the appeal?
MAT 2294 of 2024.
MAT 2294 of 2024. Preferred an appeal being MAT number
এটাও দিয়ে দেবেন তো দাদা
2024. As paid for by Mr. Chatterjee, the hearing of the matter stands adjourned for 4 weeks.
Yes. Well, kindly submit. But the other matter your lordship was fixed on 20th March. Let this also appear on 20th March.
Other matter is after compliance.
After compliance.
We never done.
After it traveled up to
We
Supreme
did
Court.
also try to be let either come with the
Traveled up to Supreme Court. That is why 2 months.
some more time may be given, my lord. Some more time may be given. 4 weeks, my lord.
Come after.
Let us come after 4 weeks.
My lord. I'm grateful, my lord.
Yes, next.
14.
My lord, Mr. Amit Pan, appearing on behalf of the petitioner, is out of town, lordship. I'm praying for not to. Mr. Amit Pan, appearing on
Where
behalf
is he?
he's out of town for some personal
Out of
reason.
town, where?
I
In
do not
which
know.
town he is?
I don't know, my lord. I was requested by his clerk, but I'm praying for one
Which
day.
town? Ask him, which town?
Durgapur. Jalpaiguri. Jalpaiguri. Siliguri.
All right, not today.
That's not applied.
Next.
16 and 17. Mr. Amit Pan is appearing on behalf of the petitioner.
Not today, next.
19.
This is mine.
Yes, Mr. Chatterjee, you have gone through that judgment. Different brief has come.
No,
Different
same brief has come. Problem is this. Judgment, judgment copy actor. Now, my dear lordship, can you see this judgment?
কোথায়? আমার ফাইলটা কোথায়? এখানে
Yes,
জাজমেন্ট ছিল। এটাতে একটা জাজমেন্ট আছে কি? তলায় জাজমেন্ট আছে কি?
Your lordship, can you see
ওটাতে
this
না,
judgment?
পরের ওইটাতে। ওইটাতে না, তলা সাদা ফাইলটার মধ্যে কোনো জাজমেন্ট আছে? নেই। Do you have a copy of that judgment?
এই judge copy
Sir,
টা-
এইটার ক- sir, এই দুশো দু না, তবে। Yes, Mr. Chatterjee.
Now, my lord, in this judgment, your lordship is indicating this paragraph. But the facts are little different.
No, I am on the power.
Your lordship on the power. Your lordship kindly come to this
Because here it has been held, it has suo motu power.
Suomoto. Yes. I have seen it. Yes. Your
Paragraph 14.
Paragraph 14. The question arises as to how this power is to be exercised by the competent authority. It has been contended by the learned senior counsel for the petitioner that unless a petition for revision is filed by the person against whom a punishment has been imposed, the power of revision cannot be exercised by the
That
competent
is exactly your submission here also.
I am afraid that the contention of the learned senior counsel for the petitioner is not tenable. A reading of clause D of Rule 29 shows that the power conferred by clause is distinct from the independent power of revision conferred by clause A, B, and C of Rule 29 CRPF rules. Though what Suomoto has not been mentioned in the clause D, but it can be inferred from the language of the said clause that the Suomoto power of revision has been vested on the officer of the ranks mentioned in the said clause, and this power is not controlled by or subject to limitation found in clause A to C of Rule 29 of the CRPF rules. The power of Suomoto revision is independent of the right of revision conferred on the delinquent employee. Such a power can be used by the competent authority to enhance or modify the punishment awarded to an employer, and it can also use to reduce or annul the punishment imposed upon the employee. Now, your lordship kindly see paragraph 15. However, another aspect of the matter which is discriminable from the language of clause D of Rule 29, while the competent authority has power to call for the records of the award of the punishment and confirm, enhance, modify, or annul the same, it can also make or direct further investigation to be made passing the such order. This means that the competent authority can pass an order of confirmation of the sentence imposed upon employee. It can enhance it. It can modify it. It would mean that reduce it or can annul the punishment altogether. The latter part of clause D provides that before passing such an order, it is not required. Now,
No.
what I'm yes.
So here we are only concerned
Now,
that whether D is separate from
now
A
your
to
lordship
C.
can see here. Yes. Paragraph 18.
1-8. Yes.
There is yet another aspect of the matter which is required to be noticed. If we have to look at the record, particularly the note approved by the respondent number 3 on 9/7/2002, pursuant
Those are on facts of that case.
No. Why fresh inquiry has been recorded?
Yes.
There the Honorable Court has come to the conclusion that this fresh inquiry cannot be ordered because you have accepted the order.
That is a different thing. That is on merits. Whether fresh inquiry. Now the question arises
in my case
whether D follows A to C or it's separate.
I'm coming to that. Now, in my case, your lordship can appreciate 3rd October, the date. 3rd October, exoneration has been done. I never preferred an appeal. Nothing has been done. Everything said and done. Then, Suomoto, whatever it may be, whether it can be done or not, that has been answered here. That said, it cannot be done.
18. Yes.
Pursuant whereto fresh inquiry has been ordered against the petitioner and show cause notice for enhanced penalty has been issued against him. It is discriminated that while proposing enhanced penalty, respondent number 3 has taken into account the report on the count of inquiry, particularly remarks relating to the cutting, overwriting, correction, and erasing of the acquittance roll and pay distribution register. So all these facts have to have weighted heavily with the respondent number 3 while proposing enhanced penalty against the petitioner. Therefore, it will be inequitable and unreasonable to initiate an inquiry against the petitioner in respect of the same facts and therefore thereafter subject to a fresh penalty. The allegation which is subject matter of a fresh inquiry have been clearly taken into account by the respondent number 3 while awarding enhanced penalty against the petitioner. It may be true that the petitioner has not been subject to departmental inquiry in respect of the charges relating to the overwriting and cutting of acquittance roll and pay distribution register. But it is also a fact that these circumstances have been weighted heavily in the mind of respondent number 3 while proposing and imposing enhanced penalty against the respondent number 3. Therefore, he cannot be subject to another inquiry and another punishment in respect of the same facts and allegations. This is also come into play. That
So according to you, fresh inquiry could not have been directed on self-same facts.
that is also
What has been done in your case?
that is also one of my ground. And I have also not subject to departmental inquiry. Writing on to the first rejected, second no. If you have done again, departmental inquiry will start. And I did not prefer an appeal. According to the rules, that is also a punishment. I did not prefer an appeal. I did not do anything. So that and they have in their charge memo 3rd October. Same thing, same date. Now your Lordship can see, this judgment has been delivered on 21st of September 2023. At the top, right hand.
6th of October 2023.
Yes. Reserved on 29th of September, the 6th of October 2023.
Yes.
This is of Jammu Kashmir High Court.
Yes. So now your junior could find out these judgments, not previously.
Not junior, this old man. Sometimes when my junior has given this, when I was not here.
I gave this.
Yes, yes. Your Lordship was there. He handed over to me on the next date. Then I saw it, I read it. What is this? Let me search. Let me now exercise my wisdom. He was not that. He was sick at that time. Terribly sick. He cannot come up from the bed at that time. He cannot talk also.
This ought to have been done before.
Why not? 25 years ago, I used to do all this exercise.
No, I'm not telling you, your junior. They will find out the judgments, give it to you, then he will make your arguments. Yes.
Now, your Lordship, can you see, this is a
What has been
judgment
held
of
there? What has been held?
Madras High Court. What I have said, that has been held.
So Madras High Court says no.
And your Lordship, can you see, this judgment is the latest, 25/3/2024.
Was considered. This judgment was considered, Jammu and Kashmir?
No, no, it has not been placed.
Which paragraph?
Paragraph 13. Your Lordship, can you see from Rule 20, paragraph 12 itself?
Yes, I am at paragraph 12.
Yes. Rule 28 is a provision for appeal. Is a provision for an appeal. But Rule 29D gives power to the Director General or the Additional Director General. Paragraph 12. To call for the records of the award of any punishment and confirm, enhance, modify, or annul the same, make or direct further investigation, provided an opportunity of show cause is issued if the punishment is proposed to be enhanced. But it is surprising to see that the rules has given such power to an authority during the proceedings of revision filed by a member of the armed forces and not in any proceedings brought up by the department. In fact, the appeal and revision provision would only indicate appeal or revision filed by the members of the force. This is an anomalous situation where an authority assumes the power through a proceedings of appeal or revision initiated by a member of the force or for being force for being aggrieved due to punishment imposed on him. In this present case, petitioner has not filed any revision, neither he filed any appeal. Nowhere in the rules it has been stated that any authority can seize the power suo motu, recall earlier punishment, and impose an enhanced punishment, even there is no appeal or revision is being filed. Now you will also kindly come to paragraph 19. 18 and 19.
Yes. Paragraph
18 and 19. 18.
Yes.
No.
वहाँ पे impose हो चुका है, हम लोग को वहाँ पे impose-
The 18 has been, a judgment has been referred. You will also kindly come to straight to paragraph 19.
19.
19.
Yes.
If the punishment for removal of service was imposed on a different charge on the basis of a conviction or in a criminal case, it would have been a different matter. But the authorities concerned have recalled the earlier punishment by invoking power under Rule 20, even in the absence of any appeal or revision filed by the petitioner. Such an order is illegal. It is not in accordance with law. Once the disciplinary proceedings have initiated on certain charges and ended on certain punishment, no question of reopening the punishment once again would arise in absence of any further proceeding taken, in absence of any revision or appeal filed by the department. As stated already in the CRPF rules, we only speak about appeal or revision
Let it
filed by the
stay.
member of the force, not by the department, and rules do not have any independent provision which would give any authority to recall earlier punishment suo motu for enhancing the same. So the order of removal from the service by exercising power under Rule 29D for the situation that arises in this case is neither proper nor legal. And your lordship, this is the Madras High Court judgment. This is the latest judgment of 24.
20.
No.
But none of the judgments are binding upon this court.
Yes, none of the judgments are binding. That I know. That none of the only persuasive value. Only persuasive value. Now, my lord, so my lord, what I am submitting, if your lordship go through the provisions of the Act, provisions of the rules is very explicit on this issue. What is that? I have already made my submission elaborately on this.
So according to you, D can be exercised if a revision is filed by a member of the force.
In case of A,
Yes. So if a revision is filed by a member of the force, that is A, then D can be applied.
then D can be applied after B and C.
Yes.
After B and C. Otherwise not. Suppose a punishment has been imposed for reduction of the rank. I did not prefer any appeal. I did not prefer any revision. Can the department suo motu take up and order reduction in the post can be converted into a dismissal from the service? That has been done in this Madras High Court case. Same thing. That cannot be done. Because it is my choice. Suppose your lordship, can you see, the analogy is this. Suppose before your lordship, I have challenged a departmental proceedings. Your lordship says, no, your is all right. The order passed by the departmental proceedings authority is absolutely correct. I did not challenge, I accept that. Can department suo motu take up that the Honorable High Court has come to a wrong conclusion?
After that, no.
No.
Because after that, no.
After that, no.
Because cannot sit in appeal over the High Court.
That's right.
But if that is not there,
That is
the question would be whether, because
No.
it is by a superior authority.
by the initiated by the department.
Yes. Initiated by the department.
Whether department has the power to initiate or not. That has been answered by the Madras High Court. And this is
In one way, Jammu and Kashmir in other way.
Jammu and Kashmir in another way. But in my humble submission,
This is CISF.
CRPF, same thing.
This is CISF. No.
No, different.
CISF, the judgment which are,
No. This is
the earlier judgment I have, your is CRPF.
Same things, same.
There is a distinction in the provision. The other judgment which are
That is
referred to.
CRPF. That is
That is
CRPF.
CRPF.
That is Sumoto is there.
Yes.
Now, my lord, today I have
Sumoto
heard
there, even if you do not prefer a revision, they can.
Sumoto. Now, my lord,
So the now question is, Jammu and Kashmir says, so but the provision is more or less identical. In CRPF,
Sumoto, what is there?
yes, that is the only distinction, but otherwise same. Those are in two separate sub-rules, I think 29A and 29B or 9A, 9B, whatever like that. Here, it's A, B, C, and D. The expression suo moto or on own motion, that is not here. Now the question would be whether while interpreting that provision, the expression suo moto can be added to interpret or not.
That is, I need not cite any decisions on that. That's the established principles of law that court cannot add, modify any word of the statute. Whatever has been done by the legislature, it has to be followed, it has to be implemented, it has to be interpreted. But that cannot add anything for something more. That's the established law. I did not want to.
According to you, in that way, Jammu and Kashmir,
it's not applicable. And this is a Chartered High Court judgment, more weight. Calcutta High Court has more weight than Patna High Court. It's always. Because Calcutta is the chartered, Patna is not the chartered. Why I am saying so? One day, I have tried to cite one decision before my Justice Girish Chandra Gupta of Patna High Court. His Lordship told me, do you know what is Patna High Court? No. Then his Lordship said that our High Court has been established by a chartered, Patna High Court by a statute. Yes, that is the difference. So, our High Court is more powerful. 80 CPC notice is not applicable for us, but it is applicable for them. That is the distinction. So, we are more powerful. We are not bound by Patna or any other, but they are bound by our decisions. That's the clear verdict of Madam Justice Gupta on that, and I have lost that case. My matter was heavily relied on Patna High Court, but I have lost that because of the another decision of Calcutta High Court.
Different thing altogether.
So this is your Lordship can see this particular sentence. Your Lordship can see here D, what the D has said.
In which judgment?
No. The statute.
Statute.
And the judgment also, your Lordship will see.
You have a copy of that?
Your Lordship has
CRPF.
Din.
दो किताब है ना किताब अच्छा पेज है बोलता yes
now D your Lordship can see
rule
29D.
Yes.
The Director General or the Special Director General or Additional Director General heading the zone or the Inspector General or Deputy Inspector General may call for the records of the award of any punishment and confirm, enhance, modify or annul the same or make or direct further investigation to be made before passing such order. But this such is qualified by A.
Which is qualified by A?
This is such order.
No, such orders is order passed under D.
No.
Because it may.
No, your Lordship is or direct further investigation to be made before passing such order. That is
such order is order passed under D.
That is call for records and all these things are dependent on this. Your Lordship can see A is very clear. The power in the between, third line, the power of revision may be exercised only when in
which clause you are placing? Which clause?
29A.
A, yes.
A member of the force whose appeal has been rejected by a competent authority may prefer a petition for revision to the next superior authority. The power of revision may be exercised only when in consequence of some material irregularity, there has been injustice or miscarriage of justice or fresh evidence is disclosed. Stop. Now, your Lordship can see, if this is according to me, it has been done, I prefer the revision. In the revision, the records are called for. For calling such record, the order is being passed. Whether the allegation is correct or not, just like call for the records by this honorable court. But if there is only one word, material irregularity, the power of revision exercised only when this is consequence of some material or otherwise, as the department fit, then this could have been. Even if suo it's not written there.
No, which clause you are now placing?
If A is included with these three words, after a fresh evidence is disclosed or otherwise department may think. If this is inserted there, then this could have been said that this is suo motu. Unless and until this is not. So the interpretation is the power may be exercised only when in consequence of material irregularity. Where the material irregularity has to be shown in my petition.
Civil procedure court to the
That is also has been taken by Mala Justice Nadira Pateria in a division bench. What is revision and there and what is revision here? That distinction, that judgment I have taken here. I was in the impression that that may be come to your Lordship's mind. 115 of the civil procedure revision and this.
Mr. Chatterjee, 115 also, same expression used.
That's right.
And there are judicial decisions which says it can be exercised suo motu.
No. Here also,
same. This here also the same thing. Suo motu is not there, but there are judicial precedents saying it can be exercised suo motu. Same. May call for the records. If you compare D with the language of 115, same.
That has been distinguished in division bench by our High Court.
Which?
That is reported in 2017 SCC.
What has been distinguished?
Revision and review. Revision in CRP, CPC and revision in here.
No. I'm not on that. I was only thinking. No, I was only thinking 29D does not use the expression suo motu.
No.
But it is same, may call for the records and such. 115 also is same, may call for the records. That expression, there also suo motu word is not used.
Your Lordship, can you see?
115.
115. The High Court may call for the record of any case which have been decided by any court subordinate to such High Court.
You did not place that. So expression
and
may call for
in
the
which
records.
no appeal lies there too. No appeal lies there too.
That is
and if such subordinate court appears to have exercised a jurisdiction not vested in by law, the High Court may make such order as the case may be, provided High Court shall not, under this section, vary or even.
But here it gives the power to vary, enhance.
That's right. But
so that I'm not on that. Only may call for the records. There also suo motu is not there. But it has been held. The courts, High Court or the district court has suo motu.
May I put this question to myself? How the High Court has the knowledge to call for the suo motu records? Unless there is a reference.
Mr. Chatterjee, I am giving you example. In a matter, you have challenged, let us suppose, order number 60. That is the order under challenge. While going through the record, court finds the order number 45 suffers from.
That is
so that is also suo motu. None of the parties have challenged. That is there.
No, maybe.
So that is the suo moto
No.
power.
That's right. But that is altogether different aspect. That one application is there containing all the orders.
No. So that order is not
And
under challenge.
that's the consistent view of the High Court and Supreme Court. Suppose your lordship, while sitting in a division bench, is that one of the single judge passed an order which is not under appeal, but the reference has been taken of that judgment, not directly, but indirect reference has been taken for that for in that case, in deciding this case. While deciding the matter, your lordship sitting in division bench held, so sees that the judgment decided by the honorable single judge in another matter is completely wrong. Can your lordship do not call for the record of that judgment? Yes.
That can be done.
That is also suo moto power of the High Court judges.
Yes.
But High Court judges are different. That cannot be put together
No, I am
with
not
this.
a High Court judge. I am saying power of revision under
That is of the High.
Now 227 you will be finding in 227 also same it has been decided.
That is the power of the honorable judge of a High Court, not of a departmental person. These are two different things. That cannot be equated. Well, a DG of the CRPF cannot be equated with the honorable judge of a High Court.
Only thing High Court exercising power under 115 at that point of time. Now the on a limited aspect 115 can be has to perform, has to consider as per the statute.
Because
227 is a different thing altogether.
Because your lordship
227 is a different thing altogether, not 115.
Court. Your lordship is a constitutional court.
No, constitutional court is while exercising 227.
Well,
but
this
not
power.
115.
No.
This is at a revisional.
No. This power has not been given to the district judge. This power.
115 is same provision.
But this is the only power given to the High Court.
Yes. 115 is High Court. 115 capital is district court.
Yes, district judge.
Same. So not getting, give me. देखिए West Bengal amendment.
No, only West Bengal amendment.
Yes. West Bengal amendment. It's not there. 115 capital A. Yes.
Normally in city civil court, a small case court, any revision will file in city civil court, district judge, chief judge, who has the power.
Yes. 115A has the power.
Yes. But the revision and review.
No, revision and review is a different thing altogether.
That has been said.
Yes. It's not review. It's revision.
No. That has been said here. Here the revisional power, the power in revision has been exercised in the writ petition, while deciding the writ petition by the honorable single judge. That has been deprecated by the honorable division bench.
Yes.
That is the judgment.
Revision is different thing altogether.
Now, here, what I want to say that the judgment of Jammu Kashmir judgment and the judgment of the Madras High Court judgment are two different, opposite directions.
It has made the task difficult for this.
Now for resolving the dispute, your lordship.
For that, Mr. Chatterjee, since this is a all India statute and that is
all India statute.
Whether
all India statute.
Other have decided in one way or the other. Only for that, I was
all India statute, no doubt.
For that, I had to also do some research.
All India statute, and all India statute has to be read. The judgment has to be read. The latest decision, earlier decision. If the earlier decision has
both
a single bench, but
and not binding upon this court.
Not binding upon this. One is chartered, one is unchartered. This is the
even if it is chartered, not binding upon.
No, not binding. Then that's why these provisions of the statute. One provision says no. One explanation says yes. But the provision clearly says application has to be done. When the application has to be done, stating irregularities, then this power can be exercised. If that is not there, this cannot be exercised.
Anything more, Mr. Chatterjee?
No.
Yes, Mr. Chobi, what do you say?
Your Lordship, I'm just trying to more
Not on
here.
facts, only on this.
Only one or 2 points. All is has submitted by London senior. He's very much senior to me. Already award has been passed. Punishment has been given. After that, this has become. Now, in this case, particular Jammu and Kashmir,
That caution.
yeah, Lordship. By particular,
I was thinking that in the subsequent.
No.
no.
Departmental proceedings.
No.
It has been completed, but no order has been passed.
It is very simple to differentiate in our case, in this case, and the Jammu and Kashmir. Jammu and Kashmir, it is clearly stated that the respondent number 3, just senior, has given this penalty. Respondent 3 penalty was awarded against the petitioner.
Which paragraph you are placing?
By
Which paragraph?
sir, I have not no copy.
Oh, you don't have any copy?
No, I have the only copy here. Just
জম্মু কাশ্মীর আপনার কাছে কপি আছে আপনার কপি
আমার copy no.
আমি সেটা প্যারাটা কপি দিই
Lordship, I'm just trying to convince on this point.
Which paragraph?
Or revise the challenge name.
কোন প্যারাগ্রাফ বলুন
Mr. Chatterjee, do you have an extra copy of this? You have.
That challenge name. Lordship, in the page number 3, paragraph number 5.
Page number 3, paragraph number 5.
The petitioner has challenged the impugned order whereby enhanced penalty has been proposed against him. Already penalty has been proposed against him, and at the same time a fresh inquiry has been ordered against him on the ground that once in respect of particular allegation, inquiry has been conducted and punishment has been imposed upon the petitioner. Already all he completed, he has awarded, he was imposed 3 penalty, 28 days quarter guard, second forfeiture of pay and allowance, a third recovery of the misappropriated amount. In our case, your Lordship, there no punishment has been awarded till today. So there is no question arise regarding revision or any appeal. Lordship. Number 1. Number 2, your Lordship, in all cases when I will award penalty against the petitioner, then he can come for the revision or any appeal. That is not published as yet, your Lordship. So our case is totally different, very much clear. Already punishment is awarded. Second, my humble submission before Lordship, that the same officer has conducted the inquiry. Here is a different 2019 reflecting the same thing. In 2019, Advocate General has taken the matter. But here in the Jammu and Kashmir, the same officer, same senior has taken the second inquiry. So this is totally different. And Lordship, that there was on 3. Lordship, page number 6, paragraph number 13. For clause D in 29D, therefore quoted provision, it is clear that the Director General or Additional Director General of the Inspector General or the Deputy Inspector General has power to call for the records of the award of any punishment and confirm, enhance, modified or annul the same. The respondent number 3 is an officer of the rank of the Inspector General of Police. Therefore, he is vested the power of the under 29D of the CRPF rules quoted above. The question arises as to how this power is to be exercised by the competent authority. It has been contended by the London Senior Counsel for this one. Lordship. So totally, here is the respondent number 3 is the same senior. He has himself conducted inquiry and he has published the award. 3 awards has been given to the petitioner. And again he has started the inquiry. And again he has enhanced, but he cannot do it. But in our case, no award has been passed. Still, stay order is there. Unless he has not get the award, the punishment, he cannot come for the revision or it.
No. He is challenging the very basis of further investigation or the further inquiry.
I have the power. 29D, I have the power.
That is to be decided. Anything more?
No.
Ashwin.
What happened?
Pursuant to the earlier order dated 24th of January 2025. Mr. Chatterjee, Lanet, Senior Advocate for the petitioner, makes his submission. Stop. Mr. Chobe, Lanet Advocate, appearing for the respondents, gives the reply to the submissions of Mr. Chatterjee. Stop. Hearing stands concluded. Judgment stands reserved.
I have prepared a written notes of argument. Only that
Incorporated this to judgment.
no.
Lordship, I have also prepared a notes of argument.
That has not been incorporated.
For that, I did not accept that on that date.
That's right. What I am submitting, your lordship, can you put it on next Wednesday or Thursday? Let me incorporate these two decisions by my learned junior, and it will be handed over to your lordship.
তাহলে করুন, hearing stands concluded না করে as paid for by Mr. Chatterjee, Lanet, Senior Advocate, list this matter next Wednesday
On 5th or 6th, any day.
in the next week করে দিন, in the next week under the in the next week for filing the written notes of argument. On that date, after filing, I will record that hearing stands concluded.
Yes.
It stands concluded. So I will give you this.
No. It is
You have
in our
copies.
laptop.
ऑर्डर क्या की ऑर्डर क्या उन्होंने कभी दे दिया था
আচ্ছা, আমাদের একটা সিআরপিএফ একটা আছে,
কিছু না বলে কিনা
এটা আমাদের
Yes. It is of the court. Mine
of the court. Yes.
So, Lordship, we have prepared the notes of argument.
File it on the next day.
Next. And
This regarding this book, a very sweet memory I have. Mr. Justice Sujit Burman Rai, while sitting in the motor vehicles court, asking me, Mr. Chatterjee, give me a book. I have given him a book. His lordship is looking after the book and delivering the order in motor vehicles matter. Some days after, his lordship's court officer forget that the book has been given by me. And no. This is I have given to the court, not for me. He has taken the book and given to another lawyer. The honorable justice, what you are doing? ওনার কাছ থেকে ধার করে নিয়ে এসেছি, তুমি এবার দিয়ে দিচ্ছ।
Thank you. Yes, call the next matter.
20. Item number 20, I am appearing on behalf of the petitioner, my lord.
In this matter, my lord, I am appearing for Mitrapur municipality. My lord, on the last occasion, matter was taken up, my lord. I was admitted in hospital at Bangalore, so I could not appear. But my lord,
On the last occasion, your lordship was curious as to whether the petitioners has been appointed as properly by way of an appointment letter or
Sanction
not,
post or not.
sanction post or not. I have prepared a my lord, supplementary affidavit annexing their
Appointment letters.
appointment letters and everything. May I try?
Order record করেন supplementary affidavit. As paid for by the learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit. The supplementary affidavit filed in court today is taken on record. A copy of such affidavit has been supplied to the learned advocate for the municipality in course of hearing of this application. When do you want?
my lord, thing is that, my lord, on the last occasion, my lord, I have seen from the YouTube that Mr. Laidi was making some submissions and has shown some judgments, referred some judgments, my lord. I need to get the copy of those judgments because, my lord, so that I can assist your lordship. Thing is that this is the third round of litigation.
We will be
Actually, matter was sent before the Act of Local Bodies. Local bodies took the hearing, passed the order that
These are
we
your
have no
appointment
power.
letters.
We have no power. Thereafter, my lord, again matter was referred to the Principal Secretary, Department of Municipal Affairs. Hearing was taken up. Secretary said, since the documents filed by the Mitrapur municipality directly should have been referred by the DLV after ratifying those documents.
that since municipality is
And the challenging that imprint order, they have come. My lord, due to flux of time, my lord, some development have been made.
Thing is that one or two petitioners, they probably they've expired. I think so.
I have to take
My
instruction,
lord.
my lord. I-
And thing is that, my lord, on the last occasion, your lordship was pleased to ask my learned friend regarding the salaries they are getting, the petitioners are getting. My lord, I got some instruction. My lord, need to submit before your lordship on affidavit, because, my lord, this is a white page publication. 11,000, 12,000 and all they are getting. And some documents, my lord, we have referred to the director of local bodies as per their inquiry. And they said those documents are under process. My lord, these petitioners, they are working with us and definitely they are serving Midnapur municipality very well. I have no objection on that. But thing is that whether the law permits for the regulation or not, that to be demonstrated before your lordship by the state London advocate who is appearing for the state. Until unless, my lord, state appears in this matter, I don't think, my lord, the matter can be adjudicated.
State chooses not to appear,
Not
what
to
can be
appear,
done?
then I have nothing to say, my lord. Your lordship can pass down.
Since my lord municipality is appearing, my lord, I would like to pray that if they could produce the document as per my lord, page number 120, my lord,
120.
memo number 2914/GA dated 10th February 2020, my lord.
Page.
Page 120, my lord.
120, that is the
120.
impugned order. Passed by the secretary.
Wherein the administrator has said that the petitioners were engaged in the sanction strength. What are the basis of those of that my lord,
Your
report?
appointment letter
Yes,
shows.
that was my lord, initial appointment letter, which is
Show me that you are subsequently appointed against sanction post.
that
That letter will be there.
that is why I am praying that if the
I
municipality
knew
could
this.
show-
For that, I wanted to see the appointment letters.
in any case, my lord, I would reiterate that two clause which are connected, my lord.
That I will consider, but whether it is against sanction posts or not, that you
Because,
know,
my lord, I have given vacancies of the municipality in that supplementary affidavit. There are lots of vacancies, my lord, and the one
lot of vacancy does not mean that you will be regularized in that post.
my lord, but I
Unless
would like
there is, you can show that you are appointed against sanction posts
yes,
at a scale of pay. There are also circulars to that effect. Giving post facto approval of those who are only appointed against sanction vacancies and in a particular scale of pay.
another, my lord,
Yes,
since
when
my
do you want?
Any day, my lord. Only I need one day to make reply of this affidavit, my lord, because I have to take instruction all the documents.
I'm giving him the copy of a judgment that will be relying, my
So
lord.
that
7th February,
7, no problem, my lord.
as jointly paid by the learned advocates for the parties, list this matter on 7th of February 2025. Yes, next. Under the same heading.
Get food.
21.
I beg to appear on behalf of the petition. But in this writ petition, I have challenged
My
the
lord,
order
before my
passed.
landed friend submits in this writ petition, my lord, may I bring to your lordship one thing, my lord, 21, 22, 23, 24 are analogous matters, my lord, both coming out of a my lord, final decision of the disciplinary proceeding. Now, my lord, on the last occasion when this matter was my lord, heard before another coordinate bench, my lord, so I brought to the notice of this honorable court that so far the final order of the disciplinary proceedings concerned, out of the 4 my lord delinquents, 3 were only given censure. They were not punished in that manner. And only one my lord employee, my lord, his my lord pay scale was down by 2 increments. So therefore, my lord, as far as censure are concerned, because the first writ petition, my lord, at number 21, that writ petitioner was only censured. So whether, my lord, this writ petition will survive or not, I do not know, because I also took the instruction from my client whether this censure, this order of censure will have any far-reaching consequences over the career record of that employee is concerned or not. So they have said nothing.
He is challenging the very initiation of the disciplinary proceedings. If that goes, everything goes. You could not have issued a censure even.
Very well, my lord.
That is his submission. Mr. Chakraborty, taking note of the fact that
No, my
the
lord.
censor has been-
What has been done? They were aware of everything. In spite of that, I have been made to suffer to the most. And words cannot describe the way I have been made to suffer because of malicious allegations. The way the bank has conducted the inquiry, everything must come in because
no
censor-
penalty to that
Sir,
extent has
why should I be subject to the penalty as rightly held by my lord when you have hold me to be not
I have not
guilty
yet
of the
held.
charges?
I have not yet held.
Observation. My submission when my lord, my observation. I'm sorry. My observation.
That
what
was to counter him.
My lord, because of the fact when the bank, a statutory authority has to apply its mind and then has to initiate a disciplinary proceedings. Somebody has recommended. Merely by recommendation, it took steps. It should also have applied its mind that when one has held that no charges are not proved, whether I can conduct the inquiry. It did not do that. There was a direction, leaving that aside. There was a direction in the recommendation that all should be transferred.
Are you ready with the matter?
Well,
After
first they will submit, my lord.
We are submitting a
Just
number
made
of
his
occasions.
point. Are you ready with the matter? That
No,
is
my
why
lord, I was under the impression, my lord, my learned fellow will first make submission, then I will reply. If it is my turn, my lord, then I have to seek, my lord, accommodation.
say so, because he has made his point.
My lord.
His
Very-
simple point is that he was found not the allegations were not proved. If that is so, how could a recommendation for initiation of a disciplinary proceedings be made?
Very well,
That
my
is
lord.
the sum and
My lord,
substance
I will
of his
satisfy, my lord. Then I will satisfy.
All right.
Only the coming week I have difficulty. Thereafter, any day, my lord,
My lord, item number, the petitioner of item number 24, he is to retire today. It's okay. Everybody knows that whatever order will be passed, it will have its effect. If the initial action goes,
Asun,
everything goes.
the learned advocate for the petitioner is present. An accommodation has been sought for by the learned advocate for the respondents. As prayed for by the learned advocate for the respondent, list this matter in the next week.
in the next week I have difficulty. Well, any other
Next
day,
week you have
except coming week, any other day. Any other.
List this matter on 13th of February.
Deeply
I'm
obliged.
appearing on behalf of the
Private
victim, private
As appearance. Yes, next.
Grateful man.
Deeply obliged, man.
23
Up
and
to
24.
Up to 24.
Up to 24.
Up to 24 act order. Yes, next.
25.
My lord, Mr. Shumon Banerjee appearing on.
What do you want?
My lord, I am for the
One
response
day's
to the
accommodation.
that matter. Your lordships kindly recall your
What
lordship.
matter? I forgot.
One day's 24th, your lordship is going to dismiss the writ petition. My lordship will take for installment.
That was a different day, not today.
No, I am not on that, my lord. Then, my lord, your lordships kindly, my lord, after 7th.
After
7th. Because, my lord, on 6th, division bench matter is there. 7th, I have 3 dismissal, disciplinary proceedings, order of dismissal.
appear.
Then your lordships kindly accommodate it.
Yes, yes.
My lord. Great.
Next.
Not today, lordship.
Not today, yes.
26.
Milord, Mr. Siddharth Banerjee is appearing.
Who is appearing?
Mr. Siddharth Banerjee.
No, we are
is
for the petitioner, my lord. This is a matter related to the People's Cooperative Bank. Mr. Mujumdar was leading me. The matter was fixed.
What do
today.
you want?
Lord, we want to proceed. Now they are seeking accommodation for me on the ground of.
Not today.
So that the matter by detaining.
Yes, yes, it will retain its position. Yes, next.
27.
My lord, in this matter, my lord, I am appearing for this school. But I have nothing left except to reinforce your lordship's observation, which your lordship has made on last occasion. But the learned
What was
advocate-
the observation I made?
Observation is that in service, the private school, in a service, in a private school.
Have you
it
seen
does
the
not-
Have you seen the recent judgment?
Yes,
Delivered on 24th of 2025.
24th of January, Supreme Court judgment, Justice Pardiola.
Yes.
There also your lordship's observation is absolute. And there is another judgment by Honorable Justice Omen Sen sitting in division bench. It reinforces your lordship's observation.
All right.
But your lordship's
Sir,
judgment was not. Mr. Chakraborty, I do not know. Possibly he is not here. There is nothing to add. Your lordship's judgment is sufficient. Even I do not force to add those judgments delivered by Justice Pardiola. It is full and final. Let that it be. Because now the trend is always to go to the Supreme Court judge. There is a book by late Mr. Arun Prakash Chatterjee, Interpretation of Fact. If your lordship sees the book, only 3 Supreme Court judgments and more than 500 High Court single bench judgment.
All right, so not today. What are
Sumon De is absent, my lord, today. Sumon De.
Sumon De for the state?
Yes, my lord.
Petitioner is not here.
Oh, my lord. My
What do you want? Dismissal?
No, my lord.
No,
Just not today. Just
Not today, yes. Next.
28.
I beg to appear, my lord, on behalf of the petitioners.
I'm led by Mr.
Yes, Mr. Mukherjee.
I beg to appear, my lord.
Yes, yes.
All parties are present, my lord, and affidavits
Uh,
are complete.
Requiring body.
Requiring body, you are the state.
Yes, require, my lord, here.
Who is the requiring body? KMDA?
Number 10.
No.
That,
No, Jindal still.
Yes.
Oh, Jindal Steel. Who is the requiring body?
Mr. Ragdanko Banerjee.
Yes, Mr. I'm led by Mr. This one number 10, my. Yes.
Who is appearing?
Yes.
He's coming, my lord. No, the other thing, affidavits are complete.
Yes.
After I begin, my lord, if the time is.
You are ready?
Affidavits are.
Yes, your lord.
Yes.
My lord, I think, my lord, they will not file any affidavit.
Yes.
It's the petitioner who was making submission.
No, Mr. Mukherjee is there. The screen is not on, but he's there. His printer, the screen is not on.
Printer আসছে না?
No, that screen is not on.
This screen is not on.
So we
Can
cannot
you-
see the.
Can you hear his submission? No.
Yes,
Yes.
My lord, my first submission is whether or not they're going to file any affidavit.
Wait.
I filed the can.
The touch started.
There's only one thing on the last occasion. There was a direction for filing supplementary affidavit,
Yes.
which I'm filing today.
Have you given a copy to them?
No,
I have not seen it.
Oh,
I
I'm
have
giving
not
it right.
seen it.
You are giving it right now.
I thought
they
that
have
it was-
to.
I have
Yes,
also
sir.
not been given.
But Your Lordship, this has nothing to do with the adjudication in the writ petition because they're challenging the acquisition process. This is the subsequent development
আমার কোথায়?
by which our company.
Do
was
you want to use that or you don't?
Yes, I want to.
Then they have to be given a copy. Should have given.
Without this also, Your Lordship, the matter can be heard.
That is your choice. If you want to use that, they are entitled to a copy.
Yes.
Let them proceed with the writ petition if we think, Your
We
Lordship.
will not be using that.
As of now, we are not.
Don't come and subsequently say, I want to use that.
There is a can. You are not filing an affidavit to the can.
Make up your mind. Subsequently, we will come up and say, yes, I want to use this.
There is a can. I'm going to press the can.
Writ petition for supplementary. We'll proceed.
Yes, Mr. Mukherjee.
My lord, this is a matter
Kind of petition.
questioning the legality and propriety of a land acquisition proceeding.
Yes.
Lord, kindly turn to page 91A.
Yes, there was an order, Mr. Banerjee, there was an order
Was not.
recording that you prayed for time to file the supplementary affidavit.
Since Mr. Mukherjee is here, that's why I thought that otherwise the matter will get adjourned on this point. So that's why if they want to proceed, Your Lordship, I will tell you what the supplementary affidavit is. It's nothing to do with the merits of the writ petition. It is only the fact that I have been taken over by a new company pursuant to a proceeding in NCLT, in IBC proceeding. Only I wanted to bring those orders before this.
No, I have a can. You are not going to.
Can has
file an
nothing to do with this.
All right, to file your
affidavits are
supplementary
separate
affidavit. Pursuant to the earlier order dated 20th of December 2024, supplementary affidavit filed today is taken on record. Let a copy of such supplementary affidavit be served upon the petitioner in course of this day. Yes,
I already served now.
আচ্ছা করুন, a copy of such supplementary affidavit has already been served করে দিন upon the learned advocate for the petitioner in course, petitioner and the state করে দিন in course of this in course of hearing of this writ petition. When 7th, Mr. Mukherjee, 7th.
7.
Mr. Mukherjee, seventh?
Seventh.
Seventh?
Yes, seventh, my lord. If you-
Seventh. This matter on seventh. Not the seventh. Next.
Grateful to your lordship.
Yes.
Grateful.
ওরম হচ্ছে নাকি?
29.
Should I appear for the respondent number 4 to 7?
ওরম হচ্ছে না।
হচ্ছে না কেন বলুন?
Should I appear for the respondent number 4 to 7, Airports Authority of India?
For the first time you are appearing, Mr. Mukherjee.
No, this matter I was there.
He had appeared.
He had appeared.
That he had been a contributor to the disposal of many applications, which had become infructuous.
Yes.
Now, this is the matter where the pay scale was sought to be reduced.
Yes.
Not pay scale, pay, not pay scale, pay. Not the.
This is that matter where Mr. Alam was saying that she will be relying upon her judgment.
She said that she will be coming with instructions from the DPE and she has filed an affidavit.
He has already filed an affidavit. And we have a very short stand on our.
Yes. No, I think this is cultivation of science judgment you wanted.
That this will not have application in this case. Because that was a matter where the pay scale was not approved on revision. This is a case where at the time of merger of two establishments, senior officers were granted additional increments in the scale.
Personal pay. That was personal to that employee concerned.
Workers were also given, the executives were also given. Workers have been allowed to retain these increments. DPE has objection with regard to retention of these increments in the scale by those officers.
Because that incremental amount was more.
No.
So far as the officers are concerned.
Right. It could be.
More liability.
No. Please recollect. Not the workers have a wage revision after 5 years. And the officers have a salary revision after 10 years. So it quite often so happens.
No, but with regard to that increments, the officers' increments were more.
Not workers' pay gets more than the officers.
Workers'
pay gets more than their superior officers quite often. But I filed a writ petition before this honorable court in respect of KOPT.
Workers getting more than the officers.
Because they have a 5-yearly wage revision.
Yes. Mr. Mukherjee will be knowing because he represents Kolkata court.
I do not know about that matter.
Mr. Shoktinath Mukherjee is leading me in that matter.
Yes, Mr. Majumdar.
Number Indian Association of Cultivation of Sciences. The claim of the writ petitioner in that case was negated on the ground that the pay scale revision did not have the approval of the government. And in fact, we have filed a review application to show that it was actually reviewed. I mean, approved.
Review?
Approved. I have filed a review. That document was not with us.
Better, Mr.
No. I have to show to your lordship that this is the document which you did not have in our possession. But be that as it may, the case stands on a different footing in the sense that was a case of pay scale revision.
Proceed independently.
This is a case of pay fixation. And fixation of pay which is personal to an employee concerned is quite different from pay scale revision. So the Airports Authority of India said that we stand by our action taken, and they had represented to the Ministry of Civil Aviation as also to the DPE that please allow these increments to continue. There are representations.
Mr. Mukherjee is actually supporting you.
Now I'm not at the time of pay revision.
Intention is that I am not governed by what the government says. So pursuant to the government's instruction, I had to curtail down the increment that was given.
Initially, you gave that.
Initially I gave pursuant to the settlement. The settlement is annexed. Pursuant to the settlement, the increment was paid to Mr. Majumdar's client.
it had to be withdrawn because of the instruction of the government.
But is it not required that at the time of entering into this settlement,
No
it
settlement
requires
was
the
there.
approval of the government?
There was no settlement.
Mukherjee
Yes,
says
no,
settlement.
they have annexed a settlement at page 152.
That
Does
is
not require the sanction of the government.
not 152 is probably the settlement of the workers, which I have
That is annexed, not with the writ petition.
Lord, I have laid my hands by way of an instance to show that workers who have had this increment have been allowed to continue. We were officers who are not covered by industrial settlement. But I prepared a list of dates. Not this may come to your lordship's aid.
Yes.
This one that you have. For us.
Remember, there were two organizations, National Airports Authority and the International Airports Authority. Now, the employees of the executives of National Airports Authority, they received a higher pay. Higher pay
You were National Airports Authority, under National Airports Authority.
because it was classified as a Scheduled A. They were classified as Scheduled A industries employees. Therefore, they were getting a higher pay. But by reason of a merger decision, not all employees of these two organizations merged into International Airports Authority of India. This took effect in 1995. This was a merger decision by a policy of the government. Now, to preserve the mark of distinction and to eradicate the possibility of discontention or protest amongst the employees, a conscious decision was taken with the intervention of all concerned, including Ministry of Civil Aviation, not the finance, that the employees of National Airports Authority who were getting a higher pay in terms of scale, they would be given one additional increment up to the level of managers, and from the level of senior managers, they would be given two additional increments in the scale.
You are
both managers and senior. This was done in 1997. This additional grant.
1st January 1997.
31st of March 1997, expert committee submitted report and suggested unification of pay scales and designation in the unified authority. Board meeting of Airports Authority of India decided executives of erstwhile NNA up to the level of manager would be entitled to one increment, and from the senior manager and above would be entitled to two increments with effect from 1/4/1996. So this was a conscious decision taken. Order issued by Airports Authority of India to unite
the decision of the board of Airports Authority.
Board. Order issued by Airports Authority of India to unite the grades and pay scales, increments to National Airport Authority employees. DPE 1999 and 2000. DPE Office Memorandum implementing pay revision with effect from 1/1/1997, pay revised after considering increment to NAA employees. Additional increments were given in the revised pay scale for workmen. Bipartite settlement with effect from 1/1/1997 was executed, affecting the increments. Then, but for the workmen also, the additional increments were recognized during the pay revision. 2002, office order issued recognizing additional increments to the executives of National Airports Authority. Then 2008 and 2009, pay revision for below board level executives with effect from 1/1/2007. 2009, implementation of pay revision by Airports Authority of India. For any deviation, proposal with justification to be sent to the ministry. That was one of the conditions in the pay revision order. If there is a deviation in the pay scale, Ministry of Civil Aviation conveyed approval for implementing 6th CPC by ignoring additional increment with retrospective effect if the grant did not have approval of DPE. If DPE does not grant its approval,
so that increment.
Yes. Then, office order issued by AAI.
What is the factual position? Did it have the approval or it did not have the approval?
DPE, I just showed you, let me straightway come to DPE's affidavit.
All right, you can proceed then.
office order issued by Airports Authority of India implementing pay revision provisionally with additional increment, 2009 scenario. MOCA, 2011, MOCA approved pay revision of workmen subject to AAI, giving an undertaking that Airports Authority of India would approach DPE and obtain approval within 3 months, not for additional increments. AAI wrote to Union of India that it was not feasible to reopen a closed issue regarding grant of increment. That will disturb industrial relations. Employer sought post facto approval for additional increments. So that's the stand of employer.
That is Mr. Mukherjee's client.
Yes. Request by Airports Authority of India to DPE to grant post facto approval to issue additional increment to Airports Authority of India employees in the pre-revised scale with effect from 1/4/1996. Office note justifying the additional. Office note justifying the additional increment granted to facilitate merger. Then note by DPE to take steps for recovery arising out of additional increments granted. Now that's where not the
2 pinches.
2 pinches.
Recovery directed.
MOCA had MOCA had directed refixation of pay after ignoring additional increments allowed as personal pay with recovery of pay. MOCA wrote to DPE that additional increments were not in order and advised Airport Authority for recovery and refixation. Now, not this paradigm shift of the administrative ministry.
Yes.
The paradigm shift in the stand of administrative ministry now. Meeting was held in MOCA and decided to send for cabinet approval. Board note was informed to the ministry. Office note of DPE for not granting additional increments. Now that's page 35 of the DP's AO.
That is the impugned order.
That's the major stand.
That is the order under challenge.
Not an order, no, it's an office note. But they have deliberated amongst themselves. It's not an order.
All right.
But that's the justification in not granting.
Yes.
AI board accorded approval for additional increments with effect from 1/4/1996. No, that's in as late as in 2015 even. Then MOCA to DPE.
No, after 2013, when it was said that this office order of 31st of January 2015, office note of DPE, item number 21, then how come the AI again writing according again accorded approval?
With the increments. Whether it was required or not, your lordship will decide that.
Yes.
Not that requirement is seeking approval of DP. That your lordship will decide. But not for the time being, please proceed on the factual basis. Then Ministry of Civil Aviation writes to DPE to close the issue. So not first Ministry of Civil Aviation and the employer writes, allow these additional grants, then don't allow, then it's a closed issue, allow. DP's note that OM dated 25th June 1999 and 26th November 2008 were issued with cabinet approval. There was no provision for additional increments.
Yes.
Demand for justice. Then MOCA prepared draft cabinet note for notional reduction of basic pay of executives.
Yes.
2 additional increments be absorbed from 1/1/2017. So they propose that don't deduct retrospectively, no recovery, reduce this prospectively from 2017. That's the 7th pay commission stage.
Yes.
AI wrote for reduction or refixation and recovery, communicated to the petitioner. But this was the first time that we came to know of all these things. AI conveyed to notionally reduce the basic pay of the executives who were granted additional increments prior to 1/1/2007 and continued to be on rolls of AI as on 1/4/2016. AI directive to refix and sending model calculation sheets. Then this present writ petition was filed challenging the notices of 2016. Interim order passed. But the interim order has been enclosed.
12th July 2016 is the impugned order. And 26th July 2016.
These are the communication, but the justification is at pages 35 and 39 of the DP's.
Yes, because AI is also communicating the decision.
My endeavor before your lordship today would be, Lord, with the passage of time, Lord, much water has flowed down the Ganges. Now, the purpose for which these additional increments was granted was a completely different cause, which had got nothing to do with revision of pay scales.
But Mr. Mojumdar, at the time of revision of pay scale, your pay at the relevant point of time has to be taken into consideration for fitment of that employees in that revised pay scale.
Fitment is not pay scale. Fitment is of pay.
Yes.
Revision is of a pay scale, say 39,000 to 70,000. This pay revision takes effect with implementation of a pay revision of say 50,000 to 1,20,000. That's revision of pay. Now, somebody was born at 45,000 in the pay, unrevised pay of 39,000 to 70,000. He has to be proportionately or correspondingly fitted in the revised pay scale.
Yes.
So that's not any other revision than that contemplated by the DP.
No, while fitting you in the revised pay scale, the question would be whether that increment will be taken into consideration or not.
But may I put it in this way? Suppose your lordships have heard about stepping up of pay. Now, in an unrevised pay scale, a junior had somehow drawn a higher pay. The senior would also have been granted an additional increment for the purpose of stepping up of his
That
pay.
is, his pay should not be less than his junior.
Now, when he would be fitted, he will be correspondingly fitted at the appropriate stage of the revised pay scale. Say 3 increments he was drawing, he had been upgraded to 5 increments. He will not be fitted in the revised pay scale at the 3rd increment stage. He will be fitted at the 5th increment stage only.
Yes.
So 1 or 2 additional increments granted to employees at the pre-revised rate for the purpose of eradicating something which was irrational cannot be restored in the name of revision of pay scale. That's the perversity. Because the concept of pay is different from concept of pay scale. And what was the reasonable nexus which was sought to be achieved by these additional increments? The nexus, the object sought to be achieved was preserve the mark of distinction. And if this mark of distinction is now sought to be wiped off by reason of just a revision of pay scale, that itself is arbitrary.
What is the ministry's DP stand?
Please take only one page, page 35 of the AO. But they have perplexed.
Because that is the only. In the affidavit? Or
in the affidavit filed by DP, not in the backsheet of Ms. Alam. Annexure R4.
Yes, page
35. The proposal of grant of additional increment to the employees of Airport Authority of India has been examined in DPE. DPE, while examining the proposal of fixation of pay of a board-level executive who was earlier working as executive director in AI, had observed that 2 additional increments in basic pay and 2 additional increments as personal pay had been allowed by AAI, video order dated 26th of February 2002. DPE, by OM dated 4th October 2012, informed Ministry of Civil Aviation that these benefits extended to the employees of AI are in contravention of DPE guideline of 1999 and hence not in order. The Ministry of Civil Aviation also, while issuing the presidential directives on 1/5/2009 on the implementation of revised 2007 pay scales in AAI, had stated that proposal regarding, please take note of this expression, 2007 pay scale, so 1996 is preserved. In AI had stated that proposal regarding existing scales which do not have the specific approval of DP, proposal regarding existing scales which do not have the approval, may be sent to the Ministry of Civil Aviation in the said presidential directives for revision of pay scales, it was clearly stated that, quote unquote, for the purpose of fitment benefit, if any extraordinary increment or increase in the pay in respect of executives or non-unionized supervisors have been granted with retrospective effect, which affects the revision of pay as on 1/1/2007. Not a retrospective increment granted with effect from 1/1/2007 for the purpose of fitment in the revised scale from 1/1/2007.
According to you, yours was in 1996.
96 and for a completely different consideration and cause. This was not for fitment in the pay scale.
Yes.
And which does not have the approval of DP, such increment or increase in pay will be ignored for the purpose of fitment or pay revision. So that was the sole consideration. Now please come to paragraph 4.
4.
Yes, of that page. Finance Division of Ministry of Civil Aviation, via their notes recorded on page 35-37, note NT, has examined the proposal and stated that the additional increment earlier allowed was for a period up to 31st December 1996 in 1992 scales of pay, but the same cannot be continued after implementation of pay revision with effect from 1/1/1997. Now, does paragraph 4 reconcile with the previous paragraph I placed?
Yes.
In a similar case of regularization of 1997 scales of pay and adoption of 2007 scales of pay in Pawan Hans Helicopter Limited, DPE has observed that Pawan Hans Helicopter Limited had deviated from DPE guidelines in grant of these pay scales to its executives. Therefore, the Ministry of Civil Aviation was requested to take corrective action as required without further delay to avoid any adverse audit observation. The instant case of AAI is somewhat similar to that of PHH.
According to you, it's not similar.
Please come to page 38. Note, I shall immediately demonstrate why it is not similar. Please come to page 38. Note,
Yes.
clause 12. Further, the linking of airport authorities case with that of Pawan Hans Limited by DPE is also not correct. Note, this is written by the Joint Secretary, Ministry of Civil Aviation at page 36.
Yes.
Is also not correct, as PHL had given scales of pay which were not in conformity with DPE guidelines.
That was a different thing altogether. Not a case of granting of additional increments.
And fixation of pay. Pay means pay in the pay point of the scale.
In the case of AI, the scales are correct. Question of increments to its employees. That is the distinction.
Fitment.
Fitment. It is only about fitment.
Yes.
But I need to cite not 2 or 3 judgments on the next occasion, and those 1999 memo and that 2000 memo, which has been relied upon in that DPE note.
When do you want?
Next
You are looking
available.
at your watch.
Next available.
That is the difficult thing. Continuity is also lost.
Yes. And this type of matter, my lord, the continuity is, my lord, desired.
Any hearing matters, Mr. Mukherjee, continuity is necessary. Mr. Mojumdar, Lance, next is submission but could not conclude due to paucity of time yesterday. That was the identical order on 10th of January also.
I forgot to
Not conclude due to paucity of time. The Union of India and the Mr. Mukherjee, you are respondent numbers 4 to 7.
4 to 7. Are you
The
7?
respondent numbers 4 to 7
4 to 7.
are represented by their respective learned councils. When do you want?
As your lordship pleases.
7th, 5th or 6th is the difficulty because there is another division bench.
7.
All right, so it has to be then in the next week.
Are you going to Allahabad?
after 7.
Want to go there and stuck there for another month.
In the week starting from 10th করে দিন, it will appear thereafter under the heading এটা কি আছে?
But may it be fairly at the top so that Lord, we can Lord, conclude this. Maybe Lord, another 2 dates because Mr. Mojumdar will be submitting on the next day. We'll give a reply, Lord. I'll be very short in my submission.
Continuing matter reviews.
Continuing আছে, continuing under the same heading করে দিন, because the earlier matters are only applications and contempt applications. Thereafter this matters are ঠিক আছে না চলো কি আছে